Good afternoon, everybody, and thank you for joining us in the 5th monthly Alps webinar. We're extremely lucky to be joined by Jonathan Naylor, solicitor at the People and Reward Department at Shoosmiths, who's going to be telling us all about the Employment Rights Bill. After the webinar, there'll be a short question and answer session. Any questions, please put them in the chat, and what we'll do is we'll put the questions and the answers in our post-webinar communication. So without any further delay, I'm going to hand over to Jonathan.
Thank you so much, Nick. Good afternoon, everyone. I would say really good to see you, but of course, webinars we can't. But thank you very much for joining this afternoon. The purpose of this afternoon's session is really just to give you some highlights briefly for about 40 minutes or so of something that's coming the direction of a lot of your clients as employers, and that's the Employment Rights Bill as it currently is. It'll soon be an act, probably perhaps even within the next week or so as it gets royal assent. But it's a huge change in employment law. It's going to really impact every employer in the UK, and it's certainly something that I think will impact therefore on your contacts and your clients, and it'd be something certainly that they're thinking of. So it may be a conversation starter for you, something that you can discuss with them in the course of your day-to-day contact with them. So we've got a PowerPoint presentation, so I'm now just going to share my screen hopefully and get the slides up for you, and hopefully this will come up. Just going to confirm to Tom that he can see the slides that I'm now seeing. If hopefully you all can. Yeah, that looks great. Okay, good. So quick update then, in as much as we can. There's a huge amount here with this particular bill. It's a massive change in employment law, and it's definitely something that will be on the radar of people you're speaking with. Before we plunge into some of the detail of those high points with the slides that we have here, just a very quick summary of who Shoosmiths are. I work in the People and Reward team here at Shoosmiths, and we're a full-service law firm. We support our clients with a range of matters on commercial, real estate, company, and various other matters, including employment, of course, and certainly some of these more complex issues that we're seeing in relation to cheapy transfers, tribunal claims, whistleblowing, and so on. So that's the nature of the support we provide to our clients. And hopefully you'll know of Shoosmiths or may have heard some of your business contacts speaking about us.
Sorry, Jonathan.
Yes, of course.
You can just see our icon in the bottom right corner if you'd like to move that off the webinar.
Oh, I'm so sorry. Yeah, of course I will. Let me just, if I close that down, Tom, yeah, there we go. All clear now?
Yeah, all good.
Excellent. Thank you. Appreciate that. So, as I say, employment law frequently changes. We do often have changes that come up every year or so. This is something entirely different, the bill that is now coming. This is probably the largest ever change to employment law in one act that we've had within the UK. And we've seen it grow even in the period since it was first introduced in October 2024, where the nature of the bill there was around 160 pages. It now runs to over 300, so it's very sizable. Some of the provisions, particularly those on agency workers and 0 hours workers, are extremely complicated, and they're going to be really difficult for employers to get their heads around. And some of these changes are absolutely revolutionary. We've not seen anything like this in certain areas. So, for example, day one unfair dismissal rights, something we've never had before. The penalty for failing to collectively consult in redundancy situations, that's going to double. It's already significant. It's going to become even greater. And some of the trade union changes will impact on all employers, not just those that have currently union relationships or arrangements. So again, it's going to be huge for every employer in the UK. It's simply a massive change that will be being brought in over the next couple of years. So, of course, all of employers need to be aware of the main points of it. As I say, we can't, in the 40 minutes we've got, we cannot cover all of the matters that would be within the Act, but we're certainly going to try and cover some of the main points as we go through. For some reason, Tom, I can't get the slides to move on from that. It's very odd. Apologies, but just bear with me a moment whilst I try and move that forward. So one of the main changes that will impact on every employer is the timeline for bringing employment tribunal claims. At the moment, we have broadly a 3-month time period for you to bring a tribunal claim in the UK. That is extended by something called the ACAS early conciliation period, and that's something that every claimant has to do first before they can pursue an employment tribunal claim. Currently, that period is 6 weeks for early conciliation. What that does mean, however, though, is that with those two elements being thrown together, and with sometimes delays in the tribunal process of actually moving the case forward and serving claims on an employer, what you find is that often it's many months after someone's left the employment before a claim lands with the employer. And they may think that they're out of the woods because it's been, say, significantly over 3 months. But in fact, they end up with a claim and it's still valid and still within time many months after the employment ended. One of my clients recently had a scenario where their employee left the employment in early February of this year. The claim was only landed and served on them in early October, so a significant amount of time afterwards, and it was still all valid and in time. It had just taken the tribunal 3 months to process the claim from when it had come into them to serving it on the individual employer. So with an extension of time limits for bringing those claims, which is being proposed up to 6 months, I think we're going to see further delay in these claims coming to employers' attention. The government takes a positive view of all this and says, well, it's going to enable more settlements to take place because there's a longer period of time for the claim to be brought. Unfortunately, ACAS early conciliation hasn't really demonstrated, which we have at the moment, it hasn't demonstrated that that will stop all those claims coming through. And as we'll see shortly, the Employment Rights Bill also means that there are far more potential claims to be brought because more people will be caught by the legislation that enables those claims. So I regret to say I take a slightly less positive view, which is that I'm afraid I think there's going to be an increase in claims. And I think it's going to take longer to get them processed and out to employers. And furthermore, just yesterday, the government announced that it's going to increase the ACAS early conciliation period so that with effect from 1st of December, that will be a 12-week period, not a 6-week one. So again, you can see here with ACAS early conciliation from December now being around 3 months, if this change comes in 2026, we're going to see a 6-month window for the claim as well. So that takes you up to 9 months. With a little bit of delay in the tribunal system in serving the claim, I'm afraid some of your clients could think that somebody who left a year ago has moved on and forgotten all about it. But in actual fact, they end up with a claim literally a year after the termination of the employment. So that could be a nasty surprise for some employers. Final point on this one is just that it also causes some real practical problems for employers in that witnesses leave the organisation, memories fade over time. So if you're defending a tribunal claim, then certainly by the time you get to perhaps 12 months after the termination date, it's going to be quite difficult to then deal with the claim that comes through. Other big changes, this is one you may well have heard about in the media. This is the unfair dismissal right. This is really significant. In the entire history of employment law in the UK, there's always been at least a qualifying period for unfair dismissal claims. That period has ranged between 6 months Generally, if a Labour government was in, it would have a low threshold, so around 6 months to a year if it was a Labour government. Conservative governments tended to put a longer qualifying period in place, and certainly the current period at the moment is 2 years. So that means until someone has been employed for a 2-year period with the same employer, they don't have the right to bring a standard claim for unfair dismissal. Discrimination cases are different, but from an unfair dismissal perspective, it's 2 years. Now, this proposal is revolutionary because it says that from 2027, it's going to be a day one right. Someone could claim unfair dismissal immediately that they commence employment. There will, however, be some form of modified light touch dismissal process, which applies in, we think, probably the first 9 months of the employment. That figure is still to be confirmed, but we're looking at around 9 months. And that's to enable employers to, perhaps in a fairly relatively quick process, remove employees that simply aren't working out within that limited period. So it's a bit like a probationary period dismissal that we have at the moment. We'll get regulations that will tell us exactly how this is all going to work and remove any doubt about that. But it's clear that even in the light touch process, there'll be at least a need to explain to the employee what's going to happen and that why they're being dismissed, and then confirm that probably in writing to show that even the light touch process has been undertaken. Now, it's clear also that that light touch process will only apply to certain dismissals within that limited period. So redundancy dismissals, where we're used to this idea of consultation and explanation as to why the redundancy process is happening, that's still going to be required, but you're going to need to do that for every employee. You can't simply say, well, you're under the 2-year limit, because there will be no 2-year limit anymore. Everybody will be caught and covered by that. Now, collective consultation is something that occurs, for example, in redundancy situations where you're looking at 20 or more redundancies at one establishment, one place of work or one organisational unit within a 90-day period. And that requires consultation with employee representatives. You may have seen those scenarios happening with some employer clients where if it's a significant redundancy restructure, then they need to consult with employee representatives. Initially, the government was looking at the idea of abolishing the idea of an establishment altogether and just insisting that collective consultation happened whenever there was a significant redundancy across the entire business. Changes have been made to the proposals, therefore we still have the establishment test, so there's still that point of where is the redundancy exercise taking place. But actually there'll be a new trigger that will be introduced as well, and that's going to refer to the overall situation in the business and some threshold number of employees affected. We don't quite know what that number is going to be yet. That's going to be the subject of further discussion under consultation and eventually confirmation. But it relates to probably a specific number of employees across the business who are affected by redundancy, or perhaps a percentage of those employees across the overall employer. Either way, we can see that there's still going to be this point of a threshold that employers will need to consider when moving to collective consultation. The real sting in the tail here with this is the second change I've highlighted there, which is around the maximum protective award that can be made if an employer fails to follow a collective consultation process. Now, this is already significant because if there's a breach of that obligation to consult collectively with the employee reps, at the moment, the starting point for the penalty for the employer is 90 days full pay, full salary per affected employee. It's significant already, but the government under this bill is going to move that to 180 days, 6 months pay. So for example, if you had 30 employees affected by redundancy, the employer fails to consult collectively with their representatives, and the representatives bring a claim, the value of that claim is potentially 6 months pay for 30 employees. It's a lot of money. and there's no statutory cap on it. It's based on the full pay entitlement. So this is going to be significant for employers, and it's a real pressure to make sure that they do collective consultation properly in scenarios where it's required. What else do your employer clients need to look forward to? Well, from next year, autumn next year, there's going to be a significant restriction on the employer's ability to dismiss people and then rehire them under less favourable terms. Some of you might remember the controversy that was stirred by the P&O case back during the COVID pandemic, when very bluntly the P&O ferry line simply dismissed employees who didn't accept significant changes to their contract of employment and then hired people on much lesser salaries in order to undertake exactly the same roles. And that really caused a lot of negative publicity, both for the employer there and also really for the legislation and the protection, because it was found to be inadequate for employees that were affected in that way. So the Labour government's very keen to change that, and what they've done instead is to say, okay, if this is going to happen, it must only happen in very limited circumstances, where if it's going to be significant, what's known as a restricted variation, something that deals with someone's pay, for example, or their contractual hours or their pension entitlement, the business is really going to have to show that it would be calamitous for them and cause huge financial distress if they weren't able to make that change. So simple efficiency savings, trying to make the business a bit more profitable, is not going to be enough to meet this sort of test. And if someone is dismissed in those circumstances where that basis of the calamitous financial distress cannot be made out, something that really goes to the heart almost of whether the business can survive without the change, well, then the dismissal will be automatically unfair, and the employer will be liable in compensation for that unfair dismissal. And even if they can get within the exception to show that it is justifiable, they still have to follow a fair process in doing it. And there therefore has to be proper consultation, alternatives to the redundancy or the changes, and what they may be offering as an alternative to the package as an overall benefit for the individual employees. So it's clearly going to limit significantly how employers can approach this sort of scenario, and certainly the flexibility that has previously been had around this, that's not going to be there. So again, it's part of this rebalancing as the Labour government seeks to put in place a more balanced approach between business and employees. And that's why I think this is so fundamental as a change, this bill. It's really something that the government is strongly behind. It feels that this is necessary to reassess and reassert the relationship between business and employees. And therefore, I think it really is something they're going to pursue. A lot of these changes have been delayed a bit, but I don't think they'll be delayed beyond the 2-year timescale that we're now facing. And certainly we expect all of these changes to be in place by 2027, in about 2 years' time. Another huge area that the government really wanted to tackle was around what it thinks is insecure employment, 0 hours contracts, temporary workers, and so on. It feels this is a real drain on the economy. It doesn't support security of employment. It doesn't support economic growth. It's too flexible. It's too pro-employer, and it needs to be rebalanced in their view. And that's why they're tackling 0 hours contracts as part of these changes. This is some of the most complicated parts of the bill. It's really difficult to understand. A lot of the processes are very complex. And frankly, some employment lawyers are of the view that it's been made so complicated that a lot of employers will simply dispense with 0 hours or flexible contracts altogether because it's too much effort, it's too much hassle almost to get this bit right. In many ways, of course, the government will be quite happy with that. More fixed, more permanent employment is what it wants to achieve. So, for example, one of the changes it's going to bring in is that those who regularly work a set number of hours under a 0 hours contract, but find themselves doing those hours fairly regularly, will be given at some point, probably after a 12-week period, the right to have a fixed contract with those hours being guaranteed. So, for example, employers at this stage may well have a 0 hours contract which guarantees the employee nothing in terms of the hours that they might work, but then the employee and the employer find that it suits them both to be working a consistent number of hours, 20 hours a week, for example. Well, if that happens over a 12-week period, then what's going to be triggered is the right of the employee to insist essentially on the employer offering them a contract which fixes those hours as guaranteed, because it's seeking to avoid what the government sees as an abuse, whereby employees are given a 0 hours contract, no guarantee as to any particular hours, but then made to work a fairly regular, specific number of hours through the period. So that should benefit employees in giving them more security and more guarantee of working hours. There'll also be further protection around a notice of cancellation or changes of any shifts. This is to tackle some really bad practice where it's been known that employees, for example, in the retail sector, have been called in for shifts only to be told as they arrive they're no longer required and they can go home and not be paid for those shifts. So here there's going to have to be reasonable notice to be given, more clarity in the regulations that will flow under the bill and the act. But it will help employees again to get some level of compensation if shifts are cancelled at the last moment. And all of this is also going to cover agency workers. So if you have clients that are used to using a large number of temporary workers, flexible workers, or indeed agency staff, then this is definitely going to bite for them. And here, the same protections that of getting a guaranteed hours offer is also in force for agency staff. So we may find that these complex arrangements whereby there's an agency supplying somebody to what's known as an end user hirer, the hirer may well end up permanently employing these people under a guaranteed hours contract because they've so regularly used them for a consistent number of hours. So we're definitely going to see change here in this sector where there's agency or temporary or 0 hours contract staff. And certainly we're going to see increased rights and probably increased claims from employees within this area. So one solution, of course, for employers might be to say, we're just going to employ them directly and give them guaranteed hours contracts. And again, the government would be quite happy with that. That would provide more security for the individual. So again, if that's a consequence of these changes, well, the government's going to take that. There are some exceptions to this, but if there is going to be an exception, well, the employer is still going to have to explain that to the individual. And of course, they can challenge it if they feel the law has not been complied with appropriately. One interesting extra element to all these changes around guaranteed hours, reasonable notice of shifts, compensation for cancelled shifts, and so on, is that they can be excluded, these arrangements, by a relevant collective agreement, as long as the rights are replaced with something else and new terms are incorporated into the contracts of employment. And what that is really a nod to is to say, again, the government feels trade unions are good, that they can help to rebalance what it sees as an imbalanced employment relationship. And they feel, therefore, that if the unions can be involved more in this sort of process, this is essentially a good thing for the employer in that they can contract out of some of these protections, but only if they reach an agreement as part of collective bargaining with a trade union. So again, that's bringing the union into the relationship and giving them more control in some ways than they might otherwise have had. And I think unions are really going to like that ability to say to employers, look, if you're struggling with all this, with the things relating to shifts, guaranteed hours, contracts, and so on, that's great. Enter into some sort of collective bargaining arrangement with us, and you can exempt yourself from it, and we'll agree these extra provisions that are in there. But of course, that's giving the union real control and real power within that relationship. And again, some employers may be concerned about that, but certainly from the government's perspective, they'd be quite happy. Okay, yet more things that are coming with this bill. As I say, the scope of it is huge, and you will see that it engages in all these different areas of employment law rights. Right now, in relation to harassment, there's a duty on all employers to take reasonable steps to prevent sexual harassment of their employees. And that's been a provision that's been in law since last October. It's going to become an even greater obligation, as we'll see on the next slide. But right now, this is the current state of the law, and this is why, for example, you'll see regularly in areas that are public facing, cafes, restaurants, train stations, and so on, you'll see signage that says things like, we don't tolerate abuse or harassment of our staff. And these are some of the reasons why, because what the government wants employers to do, and what you are legally obliged to do at the moment, is to have in place policies, robust assessment, risk assessments, resolve complaints brought by your employees, and so on. Otherwise, you run the risk of breaching this duty to take reasonable steps to prevent the harassment of your own employees. So that's the current status, and as I say, this gained greater profile last year when these changes were brought in. But even more than that, what's coming for employers? Well, from October of next year, we're going to be looking at not just reasonable steps, but all reasonable steps. Now, of course, to non-lawyers, you might say, well, what's the difference really? If something's reasonable or all reasonable steps. Actually, in law, there is a bit of a difference here, in that all reasonable steps essentially means that if there's anything that you've done that would have been reasonable that you haven't done it, you've failed in that duty. It's a really high test. And what's more, not only do employers have to do this in relation to their own employees perhaps being harassed by co-workers, but we're also looking from October next year at a duty in relation to what's known as third-party harassment, where any harassment by, for example, a member of the public to someone that works in a restaurant or works in a train station or works in any areas where there's going to be a direct interface with members of the public, well, that's going to be caught too, because third-party behaviours towards employer staff will be caught. And that really means, therefore, that particularly in sectors where there is a high element of public-facing roles, there's going to be a real obligation on employers to get training right, policies right, get risk assessments done, make sure that they have robust procedures that they follow when complaints are made, and actually do something about the harassment if anything occurs, because otherwise they will not have taken all reasonable steps, not just reasonable steps, but all reasonable steps. And of course, if they don't do this, not only is there a risk of compensation, but actually that compensation can be uplifted by up to 25% if the employer doesn't comply with their duties in relation to the ACAS Code of Practice on dealing with these scenarios. As part of these packages, we're also seeing that an allegation of sexual harassment will be what's known as a protected disclosure. It will become a qualifying protected disclosure under the whistleblowing legislation, and that'll mean, again, increased protection under that provision of employment law, where people can say they've suffered a detriment because they blew the whistle. And finally, the government is also going to try and limit the effect of what are known as non-disclosure agreements, or NDAs, in cases of harassment or discrimination. Now, again, you may have seen this in the media. This arose really from cases such as Harvey Weinstein in the States, and also the Me Too movement. And essentially, the government's very keen to stop non-disclosure, or what's colloquially known as gagging clauses, in things like settlement agreements when the case is around harassment or discrimination. Now, this is a really sensitive issue. There are circumstances genuinely where, for example, both parties might want just to leave the employment and for someone to go. They've raised allegations, but no one wants to go through litigation to establish the truth or otherwise of those allegations, and they agree a confidential settlement. Well, such confidential settlements in relation, if they involve cases of harassment or discrimination, certainly are likely to be impossible under these changes, and therefore, while there'll be confidentiality clauses in, say, a settlement agreement under which someone leaves the employment, it won't stop people being able to talk about harassment or discrimination that they've suffered at the employer. So it'll be interesting to see how that plays out. But that's certainly the current proposal, to try and limit the effect of those confidentiality clauses. So we're going on to look at further changes, but hopefully you're getting a flavour, I hope, of the scale of these changes, how much areas these changes touch in all aspects of the employment relationship. And this isn't even all of it. I've just given you, as I say, sort of edited highlights of some of the main changes, but there is still more to come, I'm afraid. And we've got, for example, changes coming to family leave and pregnancy. So there we have a situation where the government's very alive to the fact that female employees returning to the workplace after maternity leave are often in a very vulnerable position. What we often find in a very cynical manner is that some employers like the replacement who's done the maternity cover better than they like the original employee, and they say, oh, so-and-so's miles better than the person that they were covering for. We don't really want that person back. But of course, the law says, well, they have to be given that role back if it's still available at the end of the maternity leave period. What therefore frequently happens is that somehow they have returned, but miraculously there's a redundancy scenario very shortly thereafter, immediately after the protection that they've got under the maternity leave period ends. The government spotted that and has decided to try and do something about it. So it's likely that we're going to have an increased protection for those returning from maternity leave, so that they can't be dismissed for example, a period of 6 months. Again, still to be confirmed in the regulations, but we're working on a sort of 6-month estimate period at the moment, to say they can't be dismissed for around 6 months after the return from maternity leave, unless there are very specific limited circumstances which would justify it. So an increased protection for those returning from maternity leave is one aspect. We've then got certain rights which at the moment employees need to be employed for a period, generally up to 6 months, in order to benefit from. And from April of next year, paternity leave and parental leave, they'll become day one rights, so they won't need that qualifying period. And to align them with maternity or adoption rights, they'll be available to employees from day one. And then finally on this slide, bereavement leave, that's something that the government again is bringing in to widen the scope of that leave. It will cover situations now where mothers and their partners have suffered pregnancy loss before 24 weeks. And also it's expanded that 1 week of unpaid leave. It is for bereavement leave, but it's expanded the entitlement to that. So again, changes on the family leave pregnancy side, again, which will be significant, will impact an awful lot of employees, and therefore will have impacts on the employers themselves. Just looking at some of the last few points on this then, flexible working, as we come to the towards the end of my presentation, we've got a scenario at the moment where employees can request flexible working from the outset of their employment. That right's going to remain. But the current right that people have is quite limited. An employer can fairly easily refuse the request. It's only a right to request. They only have to cite one of the 8 business reasons why that could be refused, such as an impact on the quality of the work or impact on other colleagues who are undertaking work as well. And therefore, it's a right that whilst it's absolutely regularly used, it's a relatively easy process for the employer to reject requests if they wish to do so. And the compensation is limited. It's only 8 weeks, capped at the statutory maximum. So again, it's quite a limited right at the moment. Government, again, is keen to expand people's rights to flexible working and make sure that it's being utilised properly. So from 2027, there's going to be a further requirement that there has to be a reasonable basis for refusing the application, and the employer has to explain what that is. That will go a little further than we have currently, where it's often just a case of citing the particular statutory ground that the refusal has been based on. And here it's likely to require a greater level of objective evidence from the employer as to why they have refused the application. So again, essentially, it's going to make it easier for employees to request this and to be granted this. And there's no doubt that employers will have to be a little bit more on their game in terms of how they look at these requests, consider them more carefully, and make sure that they've got real objective evidence if they are going to refuse them. We've not seen yet any indication that the government's going to lift the cap on compensation for this, so it's likely that that's still going to be fairly modest. But the real risk with all flexible working claims is that it's not really the regulations themselves that's the problem. It's the idea of an indirect sex discrimination claim where someone says, well, I have increased childcare responsibilities, I made a flexible working request for that purpose, you've declined it without any really good valid reason. And what that means is that that's indirectly discriminatory against me because I'm female, and females statistically still have the greater duty for childcare responsibilities than male employees, and therefore that's indirect sex discrimination. So those are the nature of the claims we often get around flexible working. But there's no doubt, again, these changes are going to make it easier for employees, certainly, to argue that they should be granted flexible working. And the final area I'm just going to touch on is on trade union changes under the proposed bill. So this, again, is going to be huge for all employers. You might be tempted to sit there and think, well, none of the employer clients that I work with recognise unions. It's all private sector. They don't have collective bargaining or anything like that. And therefore, I can kind of switch off to this bit. Well, I'd urge you not to, just for a couple of minutes anyway, because there is no doubt for all employers, these changes will have an impact. So, for example, from April of next year, it's going to be easier for unions to make an application for what's called statutory recognition, so that they get approval of something called the Central Arbitration Committee to be able to undertake collective bargaining with employers. Now, what happens, therefore, is a union says to an employer, even if they're not recognised within a certain area, they can say, right, we'd like to be recognised within your employer. We've got a number of members now that we've signed up individually, and we think it would be good if there was collective bargaining and the union was recognised within your business. The employer might say, no chance, don't want that. We don't want to have union representation here, and they decline the request. The union can then apply to this Central Arbitration Committee and say, we made a request, it's been refused, we'd like to have what's known as statutory recognition. We'd like you, the CAC, to order the employer to recognise the union, and we think we've met the required benchmarks for that to happen. And it's those benchmarks that are going to be essentially made easier for the unions to hit. So, for example, at the moment, they need to say, we've got 10% of the bargaining unit who are members of our union. Under these changes, they'll only have to have 2% of that bargaining unit. So a much lower threshold to pass in order to start that process of statutory recognition. Further than that, though, this isn't just about recognition of unions, it's also about general knowledge of trade unions within the workplace, because again, the government's philosophy here is that collective bargaining is a good thing. Union presence in workers is a way of getting better security for individual employees, and therefore they're in favour of it. So one of the things that will come in, again, in about a year's time, is that all employers, regardless of whether they recognise a union or not, all employers will be required to give workers a written statement advising that they have the right to join a trade union. And that statement should be provided along with their contract of employment at the outset of the employment. What's more, however, it's not just new starters, it's everybody in the business, and also, and the government's consulting on this at this very moment, one of the suggestions is that this will be a repeated obligation, maybe as often as 6 months. Every 6 months, the employers have to remind all employees of this fact. Now, that inevitably is going to drive interest in trade union membership and recognition, and I suggest it's going to mean that there will be much greater union activity in many employers that haven't previously seen it. A further element of the changes is that trade unions will be able to request something called an access to the workplace agreement in order to allow them access to meet members, recruit members, communicate with potential new members who might wish to join the union, and try and drive this idea that there is recognition and collective bargaining. Now, again, an employer might say, well, I'll just deny that. I'll say that they're not allowed to have access. I won't agree to anything. The problem again is that there's oversight from the CAC, the Central Arbitration Committee. And again, if the union doesn't get what it wants, it can apply to the CAC. And ultimately, the CAC might simply impose a workplace agreement, which means employers have to allow that level of access. So again, I think you can see here, these are significant changes. It was going to have a huge impact on all employers, not just the unionised ones. So those without union presence are certainly still going to have to at least consider their approach to some of these changes. And this is all coming probably on a sliding scale between now and 2027. So we've got a sort of 2-year window, but some of these things are going to be coming into force even early in the next year. So hopefully I've just given you a bit of an insight there on what's happening and what is ahead for your employer clients. I'm just going to minimize those slides now and sort of go to Tom really and see whether we've got any questions that I might be able to answer, because I'm conscious I've taken about my allotted time there, I think.
Oh, can you see me? I think I was frozen there for a second.
Can indeed. No, I can see you. I'm just looking to see if we've got any questions there. Maybe let's have a look in the chat and see if we've got anything.
So
no, just a moment.
Well, I've got a question while we wait. So if anyone's got any questions, please put them in there now. So I mean, this all looks pretty complicated. So the government's got an awful lot on their plate at the moment. Are they really going to do all of this?
That's a really good question. Some of this stuff's been delayed already because we were expecting, for example, the unfair dismissal stuff to be in force around now. Actually, that was the initial plan about autumn of this year, 25, and it's been delayed another year. However, I think you've only got to look at how important this is for the government. It is fundamental, I think, to their programme for government. And even today, I noticed in the Guardian, Angela Rayner, despite no longer being the deputy prime minister and deputy leader, she has been writing passionately in support of the changes that they're putting forward. So I think it's obvious that there's a real drive still to implement this. Yes, I think there's been an acknowledgement that the path's been a bit bumpy so far, but I really do think they are committed to this. And certainly, I think things like two things, particularly the unfair dismissal right being day one, I think that was such a part of their campaign that they won't be able to drop that. That will have to come in. And some of the trade union stuff, it was essential to get the trade unions on board, frankly, prior to the election. And I cannot see how they can back away from some of those changes. So I certainly think fundamental elements of it will come through. Yes, there's still things to be decided. The regulations will be clearer ultimately as to some of the minutiae of the the processes. But there's no doubt a lot of this will be enforced, and I think will be enforced, by 2027.
Excellent. Yeah, well, that kind of answers one of my next questions, which was going to be, do you think we're going to see day one dismissal or day one rights, or is that going to be watered down somewhat? But yeah,
Well, yeah, although they're having a battle at the moment. I mean, this is the reason why it hasn't quite passed into royal assent yet, because at the moment the House of Lords are really struggling with it and keep sending things back. So there's been a proposal from the House of Lords to make it a 6-month limitation period, so that there's a qualifying period of 6 months before you get that unfair dismissal right. And they were quite keen on that, and consistently the government's refused that and pushed it back as a day one right. Eventually the Commons will get its way, because that is how it's supposed to work. The Lords will make the objections, they'll try and revise it, but ultimately they will probably stand aside if the government insists on its way. And so I think we'll end up with day one right for unfair dismissal. I do think that will happen, subject to that limited probationary period type light touch approach. But I think we have to accept that day one is likely to happen on that.
Right. Okay. Given the delays that we've already seen on this, do you anticipate further delays?
Yeah, I think the government will be keen to avoid that, having delayed it once. I think the other point you've got to think about is the fact that 2029, I think I'm right in saying, 2029 will be the next election cycle. If we get that far, that will be a 5-year term. So this essentially, there has to be a general election at some point by July 2029. So realistically, is the government wanting to be arguing about this sort of stuff in, say, the last year before an election? Very unlikely. Therefore, I think, 2027 is probably being seen as the trigger point. We must have this in place by then so that they can focus on other things, pushing towards the next general election. I don't think they'll want it to go any further than that.
So, yeah, with all these changes, good idea for everyone to get commercial legal expense insurance and family legal insurance then.
Well, it's certainly, I think, as I say, I'm sure hopefully those on the call will, when they're talking to their clients, they'll realize that a lot of businesses are certainly very alive to these changes and how significant they'll be. Yes, there's still a lot to be worked out in terms of the detail, but I think the basic concepts are on their radar, and it's just something that they'll really need to grapple with over the next year or so. But it's definitely going to be high profile as we get, more towards, I think, a year's time, 2026, and some of these big changes coming into play. So yeah, I think it's something that's definitely worth talking about to your clients at the moment, because they'll be, I think, definitely concerning them.
Excellent. We've got one question there. It's about the slides. So just to clarify, we're going to send an email out tomorrow. It will have the slides. It will have a link to the recording as well. And it will have some information about the next webinar, which we're planning on doing another one on the Renters' Rights Bill, probably more focused about how claims will work. But if we don't have any more questions, I think we can leave it there. So thank you very much, Jonathan, for that. Extremely informative. And thank you for joining, everyone.
Thanks very much, everybody.